Welcome back. In this lesson, we're going to be discussing the Boss Legal Playbook. That's right. Contracts, NDAs or non disclosure agreements, and non compete agreements. Look, you have to know how to protect yourself, how to read contracts in order to protect your brand and to protect your business. So let's begin. Why are written contracts your first line of defense? Look, memory fades, but that paper trail, it will endure forever. Verbal agreements, things you've discussed with people but you don't have on paper, whether intentionally or unintentionally, it could fade, and that could cause a headache down the road. Therefore, I need for you to utilize written contracts to protect your rights, your business, and your brand. Those written contracts clarify expectations for all parties involved. What are some essential contract elements? As a business owner, you must have contracts for service providers and even content creation. You don't want anyone claiming your work. In those contracts, you're going to discuss the scope of the work that's going to be performed, the deliverables, the payment terms, and the cost of confusion. Real world impact. It is estimated that 60% of small business disputes arise from unclear or missing contracts. So, again, protect your business and protect your assets by having your agreements written down, signed, and then scanned into an electronic database for you to keep for the long term. Next, let's discuss non disclosure agreements. I need for you to guard your secrets. What does an NDA safeguard confidential information like trade secrets, client list, pricing strategies, and proprietary business plans? When to use an NDA? Deploy NDAs when sharing sensitive information with employees, freelancers, partners, content creators, or potential investors. Key NDA features include essential elements such as a clear definition of the confidential information, reasonable duration, and specific exceptions for disclosure. Your NDAs could be your legal landmines. Therefore, beware. An overly broad non disclosure agreement can be challenged as disguised non competes, especially after recent California court rulings. Legal landmines. Beware of overly broad NDAs because they can be challenged as disguised non competes, especially after recent California court rulings. So, as a reminder, think about those key elements. Does it have a clear definition of the confidential information? Is there a reasonable duration? And is it a specific exception for disclosure? Keep your business safe. Make sure you research the NDA requirements in your state. Let's talk about non compete agreements and what you need to know as a business owner. Non competes historically restrict employees from working with or starting similar businesses within limited time and geographic areas. However, the Federal Trade Commission recently ruled, and they have banned most non competes nationwide because the language was just simply too broad. They did so to promote worker freedom and drive innovation across industries. In most states, limited exceptions are allowed for your senior executives, and they are subject to the existing agreements, but most other non competes became unenforceable after the ruling's effect. Because non compete agreements can vary greatly by state, I need for you to understand your state's requirements. Non compete agreements can come in handy. I teach a lot of classes and I put clauses in those. If you're registering, stating that you won't teach using my curriculum without my approval, or that you won't open up within 5 miles within a given time frame, such as 6 months to a year. So remember, if you're going to be providing a non-compete agreement to someone you're affiliated with, it has to be time bound and it has to make sense. It should not limit their upward mobility. As previously discussed, the Federal Trade Commission made changes to non-compete agreements. So let's explain the reason that the non competes were banned. The first reason is because the loss of startups. Look, if the top talent can't leave and take their talent with them, you're suppressing businesses. You're suppressing innovation. So, annual startup formation suppressed by non compete restrictions nationwide, 8.5 thousand as of 2024. Because these very smart people couldn't leave and go to another company, they also lost wages, an average of $524. How many workers were affected? An estimated 30 million American workers were previously bound by non compete agreements. What does that mean for employers? Employers must now pivot to alternatives like enhanced non disclosure agreements and non solicitation agreements, which we'll discuss in a future slide, while notifying workers that existing non competes won't be enforced. Next, let's discuss the red flags in the contracts that you sign. If the contract has vague language, that could be a trap. Overly broad or ambiguous language that could limit your future work opportunities or restrict your general skills or knowledge, that's a red flag. Do not sign that contract. Reaching non disclosure agreements. They can prevent you from using your general industry knowledge or effectively block you from working in your chosen field altogether. Unreasonable restrictions. Excessive geographic boundaries or time restrictions and non competes that go beyond protecting legitimate business interest. Another red flag would be missing key terms. A lack of clarity on critical elements like dispute resolution procedures, termination clauses, or payment terms. If you don't understand it, I need for you to seek counsel. The cheapest way to get assistance is for you to upload the contract in question and actually ask ChatGPT. You can utilize our GPT to actually evaluate your contract. Ask it about the pros and the cons. See what feedback it has. What questions should you be asking this person who provided you with this contract? And if you can afford to do so, don't be afraid to consult an attorney. So it depends on your budget. Can I tell you that I have used a law GPT to help me win a court case? I've also used another GPT, my personal GPT, to help me vet a contract. And at the end of everything that I felt internally, the GPT AI was able to reconfirm I did not sign that contract. And I asked that person to never contact me again about a partnership, because a partnership with an NDA or a partnership with, I asked that person to never contact me again because they wanted 100% ownership of content that we were creating together. Do not be in a rush to partner. Always ask questions and ask for those contracts so that you can vet them in advance. Don't trust anyone. So now that we discussed the red flags, let's talk about your sixth sense. You can sometimes know when a contract isn't right. Don't feel rushed to sign anything. I need to think about this. I'm going to run this by my business partner. I'm going to run this through a trusted friend. You all. I need for you to protect your business and to protect your brand. Whenever available, I need for you to protect your business and to protect your brand. You're never in a rush to sign a contract. Research, ask questions, go back to the drawing board, ask for more information. Can you please explain what you meant in clause C.1? If you don't understand it, you do not sign it. Those red flags, that feeling that you sense, is there for a reason. If you're going to protect your brand, you must understand everything that's in the contract and you must also agree to it. Once it's in writing, it's binding. Let's discuss alternatives to non-competes that still protect your business. Number one is an enhanced NDA, or a non-disclosure agreement. This is focused on protecting genuinely confidential information without restricting employment mobility or career advancement. The second alternative is non-solicitation agreements, in which you would prevent former employees from poaching clients or recruiting colleagues without blocking their job mobility entirely. Third, let's discuss training clawback agreements. You can recruit significant training investments if employees leave within a specific. Now let's talk about when to call a lawyer and where to find affordable help. I've already mentioned AI and how AI has literally helped me win a lawsuit. It's also helped me win grants. So don't be afraid to use the free tools that are readily accessible. But now you have additional questions. You want to talk to someone who's a pro. Let's discuss the critical moments for legal counsel before signing any contract with restrictive employment clauses. When you suspect a contract violates state or federal laws. For drafting custom contracts tailored to your specific business needs, when navigating evolving legal landscapes and compliance requirements. Here are some affordable legal resources. In some cities, your local small business actually has legal. So let's talk about affordable legal resources. In most cities, there are legal clinics for small businesses. Sometimes your law students may provide pro bono services. You have to do the research in order to find these type of services in your area. Something that is readily accessible to you would be online legal platforms such as LegalZoom, Rocket Lawyer, and Legal Shield. Nonprofit programs such as Legal Aid can also provide services to you. There's usually a wait, and sometimes, especially because this is a business matter, they may not have an assistant for you. Don't forget about nonprofit organizations such as Legal Aid. They're usually in most major cities. Whenever you schedule an appointment, let them know about your business needs, your business questions, to see if they have someone in office who can assist. You can always go to your state bar's website, State Bar Association. For referral services are also available. Whenever you want to research an attorney and seek counsel, you would go to your state's bar association's website, and from there you can do a search based upon the needs of you and your business. So let's discuss our boss tips to help you protect your empire proactively. That's right. We're doing this in advance. We're not going to be behind when it comes to contracts. Number one, you're going to start strong from day one. Don't wait for disputes. Implement clear, tailored contracts from the very first business relationship and partnerships. Next, stay legally current. What does that mean? Keep informed about evolving regulations, especially the Federal Trade Commission's non-compete ban and emerging state-level legislation. Keep your non-disclosure agreements laser focused. Remember, no vague terms. Maintain NDAs that are precise and legally enforceable while avoiding the pitfalls of creating NDAs that are disguised as non-compete agreements. Last, build trust through transparency. Foster strong relations with partners and employees through clear, fair, and transparent legal agreements. So, in closing, let's discuss your legal playbook summary and next steps. First, let's focus on your foundation. Written contracts are your business's foundation. Never rely on verbal promises or handshake deals. Strategic protection. NDAs protect secrets effectively. Non-competes are mostly banned, but smart alternatives still exist and do work. Early prevention. Watch for contract red flags and seek legal advice early to avoid costly disputes later. Maintain a balanced approach. Protect your business interest while empowering your team and staying ahead of legal risk. Are you ready to build your fortress on a stable foundation? If so, start drafting those smart contracts today. And don't forget that if you need help, you can utilize the Boss Nurse Custom GPT to help you create those contracts and to help put your business on a firm foundation. I'll see you in the next lesson.